Right, so welcome back, and we're going to talk today about the duty of loyalty. And right now, where are we at? Well, we had talked about shareholder litigation in general. We're going to come back to actually talk about litigation procedures, direct and derivative, as we close up this section. But we talked about judicial review of board decisions, and that's the duty of care. Right, and the big upshot from the duty of care is duty of care claims lose, especially if the company has elected to make a 102(b)(7) exculpation clause in their charter, in which case, basically, duty of care claims lose. And so, as we talked about the duty of oversight, we saw that there was a change in oversight claims, oversight being a failure of the board to monitor for illegality or other problems, and those purported failures have been litigated more and more under the duty of loyalty, because duty of care is increasingly a non-starter argument in corporate litigation. But the duty of loyalty, which we're going to cover today, is fundamentally alive and well. In fact, if anything, this has been an increasing area of litigation. So as mentioned, oversight has been grouped into loyalty issues in general. And part of the reason for this is that we are more and more concerned about things like how executive compensation affects executives' ability to make good decisions for shareholders. And we realize that when directors have an interest, it can not only negatively affect shareholders, but have systemic effects negatively impacting society. So what does it mean for a director to be conflicted? It means that a director stands on both sides of a transaction, has something personal to gain for it, or is involved with someone who has something to gain for it. And just by the way, I want to frame this right up front. Just because a director is on both sides of a transaction does not mean the deal is unfair. But it puts the burden on the board to show the deal is fair. Just because there is a potential loyalty conflict doesn't mean we don't want this transaction to happen. We'll see a lot of examples where good things come out of these contexts. In part because a person might be both a director of one company and maybe access to finances that company needs. In fact, in venture capital, this happens all the time. At some point, the venture capital partner who sits on the board is going to be making decisions whether or not his firm will reinvest in the company. He clearly sits on both sides of that transaction, but that's where the money's coming from. It's not necessarily unfair.
By disinterested approval, do you mean that the rest of the board, is that what you meant by the rest of the board, having to agree with this decision?
So there is a process by which we can cleanse a transaction. So bullet point 2 then is the chapter for next week, which is cleansing DCITs, cleaning or removing the taint that a conflict has. Because conflicts are not always bad. It doesn't mean the deal's unfair. And so there is a process that boards go through to, as we say, remove that taint. And that requires disinterested approval, sometimes a special litigation committee. And we'll talk about cleansing disinterested director conflict of interest transactions, or DCITs. And that'll be that disinterested approval and cleansing process. And then we, where angels loathe to tread, or whatever the expression is, judicial fairness review. When you're going to a court and asking the court to say, in hindsight, a deal was totally fair, it's a bad place to be, but we'll talk about that as well. So what do I mean by a self-dealing transaction? I mean the director is on both sides. It could be that they have a financial interest, could be they have a personal interest. We'll see examples of both. And we're going to look at Delaware General Corporate Law, Section 144, Subchapter F, to determine how to cleanse these transactions. So that's the relevant law, DGCL 144, particularly Subchapter F, because we want to get our directors into that safe harbor where they're not going to be liable for this conflict of interest transaction. There are different ways that this can go about, but the process is often going to be, as was asked, about having disinterested or independent shareholders, directors rather, or shareholders ratify the transaction. Of course, there are some problems with this. I mean, getting shareholders to ratify anything, as you've noticed, shareholders are sheep. They will generally take little interest in a company unless they're major shareholders. They have to believe the board. They don't have good access to information. So we have a couple questions to answer about the process and whether it's good or bad, but I think we need to start by understanding what these conflicts are, and then we can maybe see why they are not necessarily bad, and then look to how they can be creating liability, how we can avoid that liability. So again, what do I mean by a corporate opportunity? Corporate opportunity is when there is an opportunity that is in the corporation's line of business. So for example, you might have a company that makes iPhones, right? Makes technology, and one thing that Apple, for example, does, it buys lots of other little companies, right? Gobbles them all up and adds to its technology portfolio. So maybe a company comes along with some interesting technology. I don't know. Let's say it makes solar panels that work on watches. Got my Apple Watch here, right? Battery dies by the time I go home every day. It'd be nice to have a little extra juice during the day. Maybe an integrated solar panel on the screen would be something useful for Apple to buy. Of course, there are other companies that could use solar panels, maybe HP. Google makes watches too. Maybe it's Android Wear Watch. There are a lot of companies that could use that technology or use a thin film semiconductor for that purpose. And so this is an interesting company. So what happens if a director of Apple, for one thing, they can be directors of many companies. There's no restriction. You could be a director of Apple and be involved in other companies. You could be a director of Apple and a venture capitalist who has an investment in this technology. So you have something material to gain for it. You're cash and carry, you're 2 and 20. Your income depends to an extent on how your portfolio performs. One of the companies in your portfolio has a technology of interest to Apple. You're on the board of Apple, right? You participate in that vote, as many high-level venture capitalists do. So, are you able to be a part of that transaction? Is that within Apple's line of business? That's going to be our first inquiry. You're not usurping a corporate opportunity if it's not what Apple does. Now, this is an example where Apple would be making smart watches, integrating technology. All right, how about Chuck E. Cheese? Right? Does Chuck E. Cheese care about thin film technology for processing sunlight into solar panel for watches? Now we're getting outside the line of business. So a director of Chuck E. Cheese who happens to have an interest in so this is not going to be within the line of business. And when this matters is when you might try to take the opportunity for oneself. This venture capitalist that's on the board of Chuck E. Cheese sees the deal. Does he have to bring it to the board? Well, only if it's within their line of business. And even so, we can still use paper and process to avoid the problem. I'll give you a classic example. And we'll see if we can isolate the problem with this. So we've got commu rent, right? Com for commercial, U for like U-Haul, rent, right? They own and lease a number of commercial buildings, and they lease out one of their buildings to big box, Walmart, right? They own commercial buildings, they lease one to Walmart, big box store. Big box faces financial difficulties, and so commu rent agrees to waive some rent and some past arrears, meaning money that's owed hasn't been paid, in order to help big box get back on its feet. Now, there are some good reasons for doing this. Why might a landlord waive rents for a tenant? Are there any legitimate reasons for a landlord to waive rent for a tenant?
Save the hassle and trying to make
It's expensive. Absolutely, right? I mean, every time you get rid of a property, you change it over, especially a commercial property. You saw what happened in the JCPenney example, right? I mean, you have improvements, capital improvements that are going into the facility, et cetera, et cetera. Sorry, that was my contracts class, the JCPenney example. That was a good example of good faith and fair dealing. Anytime you switch over a commercial property, go from it being Walmart to Joe's Hamburgers, right? You're going to have a lot of changes going on there. It's expensive. That might be unoccupied. You might have vacancies for a long time. There could be real value in having Walmart as your tenant, big box as your tenant. So there are some legitimate reasons, but here, Ms. Box is a significant shareholder and a member of the board of directors of CommuRent. She's also, she's an owner, rather she's the owner of Big Box, the tenant, she's on the board of directors of CommuRent. So what's the problem with this? It might be beneficial for both parties, but what's the problem here if we got a director who is the owner of the company that's the lessee, and the lessor is thinking about waiving some rents?
The whole purpose of commune rent is to bring in rent, and so by them waiving that for a company that she's the owner of, it defeats the whole purpose of their company, so it's very self-dealing.
Yeah, it could undermine the purpose of earning some income, right? Other problems here? There are other shareholders. What do the other shareholders of CommuRent want? Right? They're not looking out for Ms. Box and Big Box. They're looking out for CommuRent, right? Everyone's looking out for their own interests. And so one major issue here is that Ms. Box is more interested. She is the 100% owner of Big Box. She's only a shareholder. It's a significant shareholder. She's only one. Maybe she owns 10% of CommuRent. Now, there's a real risk here that what she might try to do is take that money. She basically might want to do a wealth transfer. Right? Let's say that there's $1 million at stake. If you own, do a little math here, 10% of CommuRent and 100% of Big Box, and you waive $1 million rent, how much does it cost you? You own 10%, you're losing $1 million, it costs you $100,000. How much do you gain? You own 100%, you're gaining $1 million. Get $1 million. So she has $900,000 to the good if she can convince the company to waive the rent for Big Box in order for $1 million. So that's a real issue here, right? And at the expense of the other shareholders. So how should this be resolved? What should we do about this? Do we want to say, no transaction? That can't happen. We can never waive rents for Big Box. It's the directors on the board. What are some ways to resolve this? Yeah.
You could, if something came up for a vote or something like that, you could get two disinterested or qualified folks to vote on it with the consent of the other members. So
Yeah.
it's more fair.
That's great. Right. Tell Miss Box, get out of the room for a minute here, okay? The rest of us, the non-Boxies over here, are going to talk about what's going to happen to your company. You know, you leave the room, and the rest of the people, let's say that they're not interested, right? They only care about CommuRent. Well, now they're going to make a decision, at least we hope and we think, based on what's good for CommuRent. So we might be able to get Ms. Box out of the room, so to speak. Now, what are some other issues, though? So let's say Ms. Box leaves the room. You know, people are people. What are some issues with that? How does that maybe not solve the problem?
The other board members are going to say, well, she's on the board, it's going to be paying work for her.
Yeah. Yeah, I mean, we don't do the deal for her, and she's going to, you know, I mean, quid pro quo, tit for tat, what have you. Right? They're all golf buddies. They're on the links together. They're all the same 67-year-old white men in the Connecticut Golf Club who've known each other since whenever. Right? I mean, they're all part of one social circle. They may have ties to each other that go beyond financial interest. They may not be looking out for the shareholders. Also, what if the directors have a personal interest, friendship or what have you, or even other financial ties to Ms. Box? If they're outside directors, they're not employees of CommuRent. They may not be shareholders. They may not even have a vested interest in CommuRent. So they have their fiduciary duties, but now those are going to be at tension with their personal obligations, maybe other finances as well. Can you tell that this is conflicted? This is your classic conflict case. What makes this conflicted? There is a director on both sides of a transaction. That's the classic case. Now we're going to see it goes beyond this. We have cases that go beyond an actual conflict, where there's sort of an imputed conflict because of relationships. Right? But we have a director on both sides. Now, this is not necessarily bad, but it certainly raises some questions. A conflict is not necessarily bad. I'm going to say it's not a normative statement, right? It's not a value judgment. It's a positive statement. It is a state of affairs. The state of affairs is conflicted. Whether that is good or bad depends heavily on the circumstances. And what we're trying to get at is whether or not the result of this is going to be fair. So, what are some options that we have to make sure that this is fair? What can we do as a matter of law to make this fair for shareholders? Well, we have at least 4 options. We could say, flat prohibition. If you've got a director on both sides of the transaction, the company cannot pursue that transaction. The corporation cannot enter into any transaction with a person when there is a conflicting interest. Now, that does prevent conflicts from being problems. The conflicts are a state of affairs. This is taking a positive statement, there's a conflict, and making it a normative statement. Conflicts are bad. Conflicts are not always bad. In fact, sometimes they're inevitable. especially as you get into certain areas. Okay, what else can we do? We can ask the shareholders to approve the deal. The shareholders are always looking out for their pocketbooks. They have nothing to do with the directors. They don't sit at the table. They don't play golf at the country club, right? They can decide whether or not it's good for shareholder value. Okay, what's the problem with requiring shareholder ratification?
None of them are educated or don't know.
They don't care. I mean, one of these shareholders of Commie Rent is my grandma. Right? I mean, she has shares of Walmart, what have you. She's not going to care about this. Right? She doesn't know. Even if she cared, I mean, grandma happens to be a very sharp lady for 91, but I don't know if she's really equipped to decide whether or not this transaction is in the best interest of her financially. Moreover, how much time are you going to spend on this? Let's say you own a mutual fund. Yeah, and you have $10,000 in your 401k, and part of that's in a mutual fund, and you own 3/4 essentially of a share of Commie Rent, which is worth $100 a share. So you've got $66 riding on this. How much effort are you going to spend, even if you were capable? Right? Shareholders are sheep. They often do what the directors say is in their best interest. And you know what? We put the directors there to do what's in the shareholders' best interest. So now we're going to second guess that? Okay, this could work, and but there's some real issues with collective action, about rational apathy, about information asymmetry. Plus, what if we want to do a private deal? What if Facebook wants to buy Oculus Rift for $1 billion while $13 billion while the market's closed? Going to get shareholder approval for that? It's not going to be secret very much longer once you ask a bunch of people, right? I mean, you literally have to send a thing in the mail. You can't do a private deal that way, right? And sometimes you do want to keep that deal private. Okay, how about director ratification? The corporation can enter into the contract, into the transaction, if the disinterested directors approve. Well, we highlighted a problem with that. The directors may be financially disinterested, but are they personally disinterested? We're going to see how that plays out in a case involving someone you might think is pretty disinterested, a law professor at Stanford. No financial interest in a transaction involving Oracle. But, well, we'll see how that one goes down. And finally, the court could decide, was this fair? Great. I went into transactions to avoid going to court. I hate wearing a tie, and they make you wear a tie in court, so I don't litigate. So I don't want to go to court. Plus, what do courts know? I mean, Delaware, maybe they're better than some, but, they're not very good at determining value. Hindsight is 20/20. It's slow. Even Delaware, where you've got your specialty courts, is pretty slow. It's expensive. And what do we mean fair? What do we mean fair? I mean, and again, judges are constantly trying to take themselves out of the conversation, trying to take themselves out of the fairness review. Fairness isn't fair. I'm going to go ahead and just say that out loud, because as crazy as it sounds, a fairness review is one of the least fair things that you might get. It sounds good, right? Let's make sure that it's fair. But if judges can't really do it, if judges are not really capable of doing that, if shareholders, especially small shareholders, can leverage a corporation unduly because they can bring something to court, are we really getting fairness, or are we getting wealth extraction? Are we channeling money to plaintiffs' attorneys? For the most part, corporate law is based around the idea that we are appointing directors to do a job. We're trying not to sue them. So fairness review has a lot of problems. But it's an important stick in the package of shareholder options, where they can potentially defend themselves, or at least threaten to defend themselves against bad director action. Procedural fairness, substantive fairness. These are some terms that you will see as we go through what it means to be fair. Fair can have different meanings. Fair can mean that the process was fair. Fair can mean the result was fair. Now, I will posit that a fair result is very hard for a court to determine. Looking back 2 years after a transaction, what was it really worth? Hindsight being 20/20. Is that really the fair way to evaluate it? We used to have a standard that required both procedural and substantive fairness. In fact, the directors would have to show that they went through the process and the result was fair. But as time has gone on, judges will dismiss cases and rule in favor of defendants if the defendants, the board, can show either procedural fairness or substantive fairness, which helps quite a bit because procedural fairness actually is something courts can determine. What process was gone through? What result was reached? How was that result reached? Courts are in bad positions to say economically the result was fair, but they're not in such a bad position to say the way it was reached was fair or not. They can look at a cast of characters and say, these people have a relationship, these people are disinterested, the process was appropriate, the process was not appropriate, without having to say what the value of something was years down the road with hindsight. So the state of affairs are that they are today three things, each of which will cleanse a director conflict of interest transaction, a DCIT. We can show that there was approval by truly disinterested directors. We can show that there was procedural fairness, and courts will opine on that. We can show that there was substantive fairness. So let's take a look at that traditional approach, where judges intruded on a transaction, which is not so common, but a traditional conflict of interest, a traditional approach, and the case for this is Remillard Brick. Anyone want to just briefly sum up kind of what happened with Stanley and Sturgis? Ben? Yeah, thank you.
Basically, what happened was Stanley and Sturgis took away the ability of the manufacturing part of the corporation from competing and sales.
Well, what did they do? What does Remillard Brick do? I'll give you a hint. It's in... They make bricks. They make bricks, and they sell bricks. Very complicated business, making and selling of bricks, right? So, no, what's interesting about this is they actually separate the making of the bricks and the selling of the bricks into sort of two separate companies, right? And who then were Stanley and Sturgis?
I believe they were directors that were part of the selling and manufacturing portion, but
Exactly. They were directors of both, and they were owners of one. They were entire owners of San Jose Brick and Tile, a wholly owned subsidiary that was wholly owned by these directors, Stanley and Sturgis, and they were a majority owner, but not the sole owners, of Remillard Dandini Company. Now, these are majority shareholders, so they get to do a lot of things. They get to make a lot of decisions. Very rarely do the other shareholders get any say. If we have straight voting, who picks the board? The majority shareholders do, right? I don't know if they have cumulative voting. San Jose, this is a California company. Maybe they had cumulative voting, but in any event, these are major power players here, right? So what did Stanley and Sturgis do that was a little bit dicey?
well, so they're basically alleging that Stanley and Sturgis used their power in manufacturing and entering into contracts with the sales corporation. So
They use that power, and what is the allegation then? They use that power to do what in legal terms? They use that power to screw over the minority. Yeah, they use their power to the detriment of the minority stockholders. They use their power to enrich themselves 100% at the expense of the 30%. Right? They use their power to move money from one branch of the company to another so that they earned more money. And how did they do this? Did they do this under the table? Did they do this secretly?
well, I think they told them that because well, I know that the court ruled to just be terminated. And just because they told them that didn't make it unfair, so that didn't make it something they told them.
They must have told them, right? They actually had a board meeting. And what happens at a board meeting where 2 directors are going to make money and 1 director is not. What do you think the result is going to be? It's a majority vote system. The 2 that make the money are going to vote yes. The 1 that's going to lose is going to vote no. And who wins? The 2 that make the money. Now, what's the problem with this? There's an obvious problem here. They went through the right process. They approved a transaction by the board. And in fact, they seem to comply with the statute. What was the statute at issue here? Statute was California Corporate Code Section 820. As I mentioned, I hate the California Corporation Code. It is stupid for many reasons, including this one. Right, under California Code Section 820, it says, no interested director contract is void or voidable if any of the following exists. 1, there is director approval. 2, there is shareholder approval. Or 3, the deal is fair. Now, did any of those 3 things happen here? Did we have director approval? Yes, we did. What's wrong with California statute? It doesn't say disinterested. So, when you have a bad statute written by some legislators that don't understand corporate law in a powerful state in our country, what do the judges do to correct that imbalance? They make up the law and they say, and I kid you not, they say that although California Corporate Code Section 820 says, if any of the following exists, they say, well, that can't be the case. Any means all. So I just finished teaching a brief course on statutory interpretation, and I can tell you, any does not mean all. Any means any. But obviously the statute is broken, right? Why is it broken? Because if a majority shareholder can appoint all the directors, and if the directors can approve a transaction, then the shareholder can enrich him or herself at the expense of the minority shareholders. And under Section 820, they can do that all day long. So the court does not want to reach that result. The court wants to reach a more equitable result. Because it finds, factually, this whole setup, this whole corporate structure was part of a plan, a scheme. Stanley and Sturgis want to obtain profits from the sale of bricks manufactured by the 2 manufacturing companies that would ordinarily go to the companies in which there were other shareholders. They want to take 100% of the profits instead of just 60%. Right? They want to screw over the other shareholders. And Section 820 is going to let them. But the court's not. The court's going to read the statute in a contorted way to avoid an unfair result. It finds, right, and there's the statute there. In fact, here's the statute, in case you want to take a look at it. If you don't believe me, it really does say any. If any of the following subdivisions exist, also bad drafting, subdivisions don't exist. The circumstances in the subdivisions exist, right? Come on, California, get your drafting together, right? The fact is disclosed and approved. So the interested directors can ratify their own self-enrichment at a meeting. Obviously a bad statute, resulting in bad case law. Contorting the words, you know what, any doesn't mean any. The transactions that are unfair and unreasonable are voidable. Now, again, are judges supposed to be in the position of rewriting bad laws? No, that's not the role of judges. But here, the law was so bad, so obviously wrong, that our judge here really rewrote those principles. Right, Section 820, it says, does not permit an officer by abuse of power to obtain an unfair advantage or profit for himself at the expense of the corporation, the court finds. It would be a shocking concept of corporate morality. Is there corporate morality? I'm not so sure. But anyway, shock corporate morality to hold that the majority directors or stockholders disclose their purpose and intent, they may strip a corporation of its assets to their own financial advantage, and minority is without redress. And so in the instant case where there is uncontroverted evidence that the majority used their power for their own personal advantage to the detriment of the minority shareholders, the California court will effectively rewrite the law to say something it does not say to avoid an unfair result. Well, that's the beginning of our story, but thankfully it's not the end. I think Delaware General Corporate Law is written much better. Section 144 and the Model Business Corporations Act has done a much better job of clearing up this situation, but this does raise an initial problem. What is the problem raised by BRIC? BRIC says corporate formalities don't solve the problem. Corporate formalities don't matter. What other factors might matter more? Fairness, substantive fairness, procedural fairness. BRIC raises the important point that formalities are not the end. Corporate formalities are a safety catch. They reduce the likelihood that interested directors can take advantage of a corporation. The reason that we have formalities is that when you put this to a board vote, it makes this stuff public. And in fact, the non-interested directors became aware of the scheme because they were asked to approve it. And of course, they refused. And then they followed through with their fiduciary obligations, informed the shareholders, and the shareholders sued. So this did work to an extent. But if a majority's decision of the board without formalities were enough, it would be too easy for shareholders who have a significant portion to screw over the minority. Right? And the purpose of corporations is not to allow the 51% to take advantage of the 49%, but we have fiduciary duties in place for exactly this reason. So, as I mentioned, I don't like the California law. I think it's ugly. I think it's bad. And it was a uniquely bad set of facts for our judge. He really had no choice but to contort the rule in order to get us to a better result. Right? And so what is the outcome? What is the lesson from BRIC? Is that, and this is important, that fiduciary duties trump formalities. It's not just about the process. It's about the process getting us the result that we want, the result being fairness. So what does all that mean? I'll leave that on the board for you to look at in the background, right? Factors that we're going to look at to see if things were fair. Now, this is hard because what the California court did by twisting 820 is it eliminated procedure as a way to cleanse because it didn't say disinterested approval. It now said we have to look for fairness. So we have to look at what? Market price for similar goods and services, cost savings with doing business with an affiliated firm versus a non-affiliated firm, other considerations that show the directors were acting on behalf of the shareholders. Very hard to prove these things. Very hard to prove these things. Now, thankfully, the statute was amended, and under the amended statute, it requires the interested directors to recuse themselves. But essentially, the California court is doing something important. It's recognizing that process is not enough. Process is a means to an end, not an end in itself. And if the process is broken, the court will try to fix it. But here the bigger problem was the statute was nonsense. That brings us to modern law. And we focus here on Delaware. The NBC Act is similar. California has come around and is a bit better. Delaware Section 144 says that an interested transaction will not automatically be void or voidable if there has been informed, disinterested shareholder approval, or informed shareholder approval, or the transaction is fair, which now we see can mean either procedural or substantive fairness. This is a typical statute. It looks very similar to the MBCA, which we'll see in a minute. Question that's not resolved here. So what do you have to do to have a meeting of directors? The directors want to have a meeting about an opportunity that comes up. What has to happen, we learned this last semester, for directors to have a meeting?
Did you give notice?
Notice, if it's a special meeting. It could be a regular meeting, but you absolutely need notice. And then a quorum at the meeting, and then you need a vote. Usually it's majority. So, do interested directors count in the quorum? They can't vote. We know that. We need approval by the disinterested. Do they count to the quorum?
They should,
Why should they?
because they're still part of the board.
Okay?
They're still a member of the board, they still count towards quorum, they just still can't vote.
So so you're saying that they should just because they're members of the board, but what bad procedural result can happen if they don't count toward the quorum? Let's say there are 7 directors, and the quorum requires 5 or 4. What if the quorum is 5 and 3 are interested? How do you approve this transaction? It's no longer possible to approve the transaction. If the directors did not count toward the quorum, you couldn't even hold the meeting. Now, the directors being in the room could have an undue influence. They may be asked to kind of wall themselves off. But, in fact, interested directors can be counted in determining a quorum. And in some of these cases, so many of the directors are interested that they are needed or there cannot be a vote at all, eviscerating this possibility. So, can interested directors be counted in determining a quorum? Yes, they can. So, how does 144 work? Is this a safe harbor? If you do these things, are you safe? Probably. Probably. This reads like a safe harbor. It reduces judicial scrutiny. And if you do these things, there should be a certain amount of certainty that the transaction will be enforced. Now, it turns out, actually, just a little side note, that the Delaware Chancery Court has had some challenges in interpreting this. Again, this is just sidebar, but there was a case, Lawrence, 1976, that said that 144 merely removes an interested director cloud where its terms are met, but it does not remove the transaction from judicial review, creating a little bit of uncertainty as if this is whether a true safe harbor. This is only a safe harbor if performing these things means the court will not review it. It does not say that. It does not say that if you do these things, the court will not review the transaction. It says it will not automatically be void or voidable. It doesn't say that it will never be void or voidable. So we do have a 1976 case which said that it doesn't do that, although that is an outlier. And we have a 1987 case where in dicta, the court said, approval by fully informed disinterested directors under Section 144A1 or disinterested stockholders under Section 144B2 permits invocation of the business judgment rule. Again, permits, and limits judicial review to issues of gift or waste with the burden of proof on the party attacking the transaction. We still have some specter of review, but as transactional attorneys, get yourself in here. It looks like a safe harbor. We don't seem to have had any major cases since 1987, even in dicta. 1976, the last time this was raised. Courts don't want to be reviewing this kind of stuff. All right, let's take a look at our next case, which is Benihana of Tokyo. This is kind of a colorful case. And so what happened here? Well, we have a couple colorful personalities. And as kind of evidence, like anyone been to Benihana? Well, there's like a local one here, right? Yeah. What's the local one called?
Maybe it's called Benihana.
Yeah.
There's also, well, there's local hibachi kind of places. Yeah.
There's several hibachi.
There are hibachi restaurants. And so what do you get there? Like, what's the experience? It's really like dinner and a show.
And then they go to front of you.
They cook in front of you. They light things on fire. They toss eggs into their hats and all that kind of stuff. And it's kind of interesting. I mean, it's kind of like they say pets resemble their owners, which I think is also true. I don't actually, it probably is the other way around. I think people probably select pets that remind them of themselves. But similarly, I think corporations do have a character. They do resemble their owners in some ways, especially close corporations. And so this is a very colorful company, very flamboyant, and the people who were involved in it were also. Rocky Aoki founded it, and this is a picture of him. He was so flamboyant and colorful that he was implicated in some insider trading. He sort of took things liberally. And anyway, Benihana enjoyed some serious popularity when it first opened, but it actually entered into a period of some decline. Oh, and by the way, anyone else know another famous Aoki? Steve Aoki, his son. So by the way, and he's famous for throwing cakes in people's faces. So, like father like son, I guess. Another fun fact, by the way, did you know that Steve Aoki has a Bachelor's of Arts in Feminist Studies from UC Santa Barbara? And he has signed several major groups, and he is the son of the Benihana fortune. So
Also has a major master's in sound production, sound theory.
he has a master's in sound production and sound theory. Yeah, and I think he's a pretty good DJ, kind of fun guy. Throws cake in people's faces. So if you go to one of his shows, don't go up front unless you like cake in the face. All right. Now, we've also got another colorful guy, John Abdo. Now, John Abdo is one of these telemarketing guys, right? That's actually a picture of John Abdo with his shirt that says, "I'm a doer." I don't remember exactly what he was selling. But he had one of these telemarkets, and his picture says, "Thank you for visiting my site. Everything here has been capital T tested and capital A approved. I wish you the very best of health and success." So that's John Abdo, who's also a director of Benihana's. We got this whole nice cast of characters here. And he owns 30% of the company. That's a big chunk. He serves as the director and co-chairman of BFC, which is a financial company. He's got money. He's got money, and what does Benihana need? They need money. Right, because it turns out people are not into old, dated restaurants when they go and get their hibachi. They want something fresh and exciting, right? The whole point of it is the show. You can't just have the same show for 20 years. So they want to get a line of credit. It's a type of financing. They had also looked at issuing preferred stock to raise some money, different ways companies can raise money in order to renovate the company. So the board authorizes a raise of $20 million in equity, and BFC Financial, as I mentioned, owned in part by John Abdo, who is a director, right? Is going to purchase the shares. So what's the problem? No problem? It's all good? We got a director on both sides. We have a director who is also on the other side of the transaction. The director of Benihana is also an owner, 30% owner of the financial company that is buying the shares. He stands on both sides of the transaction. This is a classic conflict of interest transaction, a DCIT, a director conflict of interest transaction. And so what happens? Well, the board approved it. And as a result of this, what happens when you sell stock? The other shareholders have less of a percentage. Now, that's not always bad, by the way, of course. You think about it this way, right? Anyone here like pie? So you cut a piece, right? Okay, so you got to have a piece of pie. So you have two choices, right? You have it. There's like a little mini pie, this big around. I'll give you a half of it, or I'll give you an eighth of a pie this big. So you can take the eighth of the pie that's this big, because you know what? You like pie. You want more pie. That's what people who like pie want. More pie. Now, which is a bigger percentage? 50% of a small pie, or an eighth of a large pie?
Based strictly percentage.
Based strictly on the percentage. So what happens when we add shareholders? Well, two things happen. Hopefully, well, for one thing, we carve up the pie. Your piece gets smaller. There's more people in the pie, your wedge gets smaller. But there's more money in the company. If you did it right, the pie gets bigger. And you end up with more pie. And by the way, how is law school like a pie eating contest? Law school is like a pie eating contest where the prize is more pie. Because if you do well in law school, you get to work hard for the rest of your careers. True fact. True fact. Just like a pie eating contest where the prize is more pie. So if you like pie, you're in the right place. All right, so Benihana's director, or Steve Aoki rather, wait, not Steve, it's Rocky Aoki. Rocky Aoki doesn't see it this way. He just likes to have a big percentage of pie. He doesn't see the whole picture. In fact, he might disagree with the renovations. He came up with the concept. He might think this place is perfectly good. And so he sues. Was Benihana authorized to issue the stock? Was John Abdo's participation improper? Was the transaction approved? What did the court say? See a nod? Was the transaction automatically void or voidable? No, the transaction was properly approved. Why? Well, what does director approval require? Let's look back at 144. We have, at least I think we have, at least only 2 cases raise a specter of doubt that I'm aware of. I think we have a safe harbor. A safe harbor that says if you have disclosure and approval, either by disinterested directors or disinterested shareholders, we have a safe harbor, right? We have a safe harbor, and the court here finds that this now is simply a matter of business judgment. We're not going to look at it as a breach of the duty of loyalty. Just because John Abdo stood on both sides of that transaction does not mean it was unfair or wrong. And if you look at it, there's still Benihana today. I don't know how many of you would go to it if it were still in its 1970s garb, right? One of the reasons we go to restaurants, we want a nice experience. Sometimes you need to paint the walls, right? Do things like that to keep a business running. So maybe in the long run he ended up with a little bit more pie, but he didn't see it that way. Why did he sue? Well, as I mentioned, he said that he was going to lose the share of his pie, but is it really, what is the difference between 51% of a small pie and 1/8 of a large pie? Now let's just assume, just for purpose of argument, right, that 1/8 of a large pie means you get more pie. And we all like pie, so we want more pie. But there is something fundamentally different about having 51% of a small pie versus 1/8 of a large pie. What's the difference? Control. You can control the small pie. Yeah, that pie is, although you only get to eat 51% of it, you get to determine the fate of the entire pie. You rule that pie. It is your decision as to when it gets eaten, right? Similarly, in a company, if you own 51%, you decide when it gets sold. You decide when it issues dividends. You decide many, many things that you no longer get to decide. So, some people like to eat pie. Others like to control pie. And in this case, Rocky wanted to control the pie. Still, Delaware General Corporation Law Section 144 said this transaction is not automatically void or voidable, and probably said it was within a safe harbor. Because we went through the right paper and process. The board was fully informed of the decision that it was making. What do we learn from this? 144 is broad. It has a really broad reach. And so long as the board is fully informed, we're not going to challenge these transactions. They have to be properly approved. So what does that mean for process? Process is the gold standard. Section 144 seems to create a safe harbor for interested transactions if material facts are known and the board, in good faith, authorized the transaction by a majority of disinterested or independent directors. So that means that courts have a new role. That role is review of process. They're not asking whether or not it ended up making more pie for Rocky in the end. They're asking whether or not the process was sufficient to protect the disinterested shareholders. The process in Vermilliard Brick was clearly lacking. The 51% holders took advantage. Here, the minority shareholder is complaining that he was taken advantage of. But the process here, we have the disinterested approval, and we say that is enough to protect the shareholders. Something similar comes in subchapter F out of the MBCA. Very similar to the result in 144, where we have a DCIT. A DCIT is defined as a transaction where the director is a party or has knowledge and material financial interest known to him, or knows a related party has a material financial interest. So this captures the concept, a little broader concept that we'll come back to in Oracle, where we see a party can be implicated even without a financial interest. So, under subchapter F, where do we get to a safe harbor? How do we get to a safe harbor under subchapter F? Similarly, the transaction has to be authorized by what the MBCA defines as qualified directors. And this is a better definition. I often find Delaware has really good laws on this point. I like the MBCA a bit better here. Why? Because qualified director captures both independent and disinterested. Disinterested means you don't have a financial stake. Independent means you're not beholden to or controlled by someone who does. And so they define qualified a bit more broadly. Came out of the case law in Delaware, and so it does work its way into the Delaware law that you have to be both disinterested and independent, not controlled by. Again, see Oracle for that. Qualified director is someone who does not have a conflicting interest in the transaction and no material relationship with a conflicted director. Now, although I like that it defines things more clearly, I think that might be a little broad. But hey, no one's asking me to write the law. So that's what the law is in subchapter F. Or we can, of course, go for the entire fairness standard, which means that the court is going to have to look at whether the transaction, with hindsight, turned out to be fair. So again, we have our statutory fairness test, board approval works, shareholder approval works, or we can have court-determined fairness. So subchapter F ends up looking a lot like DGCL 144, a little bit of wrinkle about how a qualified director is defined. There's one problem that remains with qualified director, the same problem I mentioned earlier, all those 67-year-old white guys playing golf together in their country club in Connecticut, right? What's a problem that happens when the entire decision-making machinery of a corporation are all a bunch of people